My lord, that is met.
Page 2, item 4 to 9.
My lord. Item 4, my lord. Only taken of 2 weeks after for the filing of consolidated lesson petition.
4.
What is your prayer? What is your prayer?
Only taken of next 2 weeks after.
You are appealing for the appellant?
Urgent. Consolidated petition not filed.
Second copy.
That's why.
Appellant.
Yes.
At the request of your Miss Chitra Pari.
No. On behalf of Chitrapat.
What is your good name?
The
Draupadi
appeal
Mohanty.
memo was allowed. Appeal memo was amended by order of this honorable court. She is required to file the consolidated appeal memo.
So sir
Now
is asking what is the name? It is going to be adjourned.
Name of the council.
Yes.
Draupadi Mohanty.
At the request of Ms. Draupadi Mohanty, learned counsel appearing on instruction of Ms. Chitra Pari and counsel to the appellant that the matter will listed on
20.
2 weeks after.
28th of July 2023. In the meantime, the consolidated memorandum of appeal shall be filed. That apart the defects as identified by the registry shall be removed by the next stage. It is made absolutely clear no further accommodation will be made for this purpose. Stop.
Consolidated appeal memo may be served.
That is we have filed.
Yes.
Obliged.
Page 3, item 10 to 15.
I beg your pardon, my lord. Item number 10 may be taken off 1 week after, my lord. I'm appealing for the petitioners, my lord.
You are appealing for the appellant
Yes, my lord.
at the request of Mr. K. This is you are taking the consecutive adjournment. What is the
No,
problem?
my lord. Last time it was hard, my lord.
Okay. At the request of Mr. K. Swine, Learned Counsel appearing for the appellant, let the matter be listed on 10th of July. 10th of July, 2023. Who is appearing for the state? Any Mr. M. K. Khantial and Additional Government Executive appears for the respondent. Okay, next.
Page 4, item 16 to 29. Page 5, item 30 to 36.
Item number 34. The appellant has filed a miscase for withdrawal of the writ appeal, my lord. I am for the appellant. That is, my lord, IA number 3552.
Have you filed an application for that?
My lord, for the withdrawal of the writ appeal, my lord.
It is 33552.
My lord, sorry,
Which
my
is
lord.
the IA?
That is IA number 3552, my lord.
3552.
My lord. That is there, my lord.
Appellants by means of this application 6 leaves of the court to the writ appeal being WA 509 of 2016. We do not find any impediment to allow the leave to withdraw. Accordingly, this application stands allowed. Your good name is?
My lord, P. Das, Praveen Das, on behalf of Mr. S.K. Das.
On behalf of Mr.
S.K. Das.
Just before hard silence. Is it allowed? Mr. You are appearing there?
Yes, in 34 I am also appearing for
Mr. K. Is appearing for the respondents. The opposite party is just stopping the appeal in view of the order passed in such cases. This appeal stands dismissed as withdrawn.
Obliged.
Page 12, item 37 and 38. Page 13, item 41 to 49.
My lords, I may be pardoned. I am on virtual mode, my lords. My lords, item number 46, I pray to be taken up, my lords. Eviction matter. Eviction has been fixed to 29th, my lord.
All right, we'll take up the matter 46 point out.
He mentioned it yesterday.
Yes, next.
Item page 14, item 50 to 55. Page 15, 56 and 57. Page 17, 58 to 60. Page 18, 61 to 64. Page 19, 65 to 70.
My lords, I'm appearing on behalf of Ms. Sarita Panda. She cannot appear today due to personal exigency. She is not in the city.
In which matter you are mentioning?
Mr. Counsel, which item are you mentioning?
My ladyship, I'm mentioning item 58.
Thirty-one January 2023.
Okay.
31st January 2023, my lord's order. There your lordship is directed to produce any scheme for regularization by the appellant.
You are referring to the order dated?
31st January 2023, my.
All right.
If he cannot provide, my lord, I can provide if your lordship will grant me some time. Because the schemes have been framed by the state government, I can provide all these schemes.
All right, we'll take up the matter on 6th.
My
Yes.
lord, the problem is the appellant is going to retire on 30th, but she has rendered more than 27 years of service as an ad
We'll
hoc employee.
consider on 6th, we'll consider on merit. If you decide in your favor, you'll get all the benefits. Right?
Right.
6, because he produced this scheme
Yes.
as per the
As
order
per
of this
direction,
court
he
of
had
the
to produce,
31st
my
of
lord.
January, also supply a copy to
As per direction, he had to produce because we have framed all the schemes, I can produce. Your lordship see that he had to produce the scheme.
No, you could not produce that scheme.
No, scheme is not.
So on my
But
behalf,
he
I am
says,
saying.
he
this
says
all.
that he will produce the scheme. Let it come on 6th.
Yes, no.
All
On
right.
6th.
Let the matter be listed on 6th of July 2023 for disposal. In the meanwhile, we request Mr. M.K. Kuntial and an additional government advocate to produce the scheme, if any, for purpose of regularization of is contractual.
We have framed 4 schemes. 1 scheme for ad hoc, 2 schemes for ad hoc, and 2 schemes for contractual.
regularization of
All the
contingent
notifications I will
ad
give.
hoc, contractual, daily wages, etc.
Different categories of employees.
All right. Mr. Arin Naik and council has appealed for the petitioners. On the day, no adjournment will be granted on that day. So Craft River is a very small issue is involved.
Very small school.
All right. Yes,
I-
Mr. Naik, you also collect the copy of this scheme
I will call.
from your friend and
Well,
come prepared.
I will
Yes,
call-
6.
call-
Item 6.
May I please your lordship? I'm on virtual mode, my lords. Am I audible, my lords?
Yes, yes.
My lords, this is a case where the petitioner's father, the original petitioner, had purchased a piece of property in 1960. About 50 years thereafter, a proceeding under section 23 was started that the land was taken from a scheduled caste person without requisite permission. Now, my lords, the person to whom the land belonged is a patra, and patra does not come within the schedule of presidential orders schedule, my lords.
Okay.
So on that ground, it was contested, but unfortunately, an order of eviction was passed, which was assailed in appeal. The order got confirmed, and thereafter the revision was preferred. Revision was, my lords, due to inability of the petitioner to appear on ground of his illness. The revision was dismissed for non-prosecution, for which the petitioner came up before this honorable court, before the honorable single judge. And my lords, at page 35 is the order, Annexure 6 is the impugned order, where on one ground he allows the substitution. In the first paragraph, he allows the substitution, but thereafter, he goes on to dismiss the writ petition on the ground that the person was dead before the writ petition was filed. Now, my lords, even in such cases, the law is settled, laid down by the Honorable Apex Court that it cannot abate, my lords. Because the state was a party and it was the state's order which was being assailed. And my lords, there's a judgment to that
Mr.
effect.
Bharti, are you prepared on merit?
My lord, what your lordship will find in the impugned order, the honorable single judge has not decided the case on merit. Only on the ground that the petitioner had knowledge about the death of the opposite party number 2 much prior to filing of the writ petition. So he, according to the averment made by the petitioner himself in the IA for substitution. So the view of the honorable single judge is that since you are aware of the date of death, by the time you filed the writ petition, but you implicated a dead person and pursue the case, that is why it is not maintainable. On this ground, so if this ground will not be found sustainable by
What is the foundation of coming to such inference? What is the foundation before the learned single judge that the information that the petitioner has the prior knowledge before?
That is his own averment. Your lordship may kindly see para 2 of the impugned order at page 35.
All right, let us see.
Coming back to the entertainability of the writ petition, it appears the petitioner himself has a disclosure through miscase number so and so regarding death of opposite party number 2 since 3/8/2002. The writ petitions appears to have been filed on 15/1/2003, undisputedly involving a dead person. In the circumstance, this writ petition is not meant to stand dismissed.
Is it a ground for a dismissal of a writ petition?
That
Is there no other alternative for justice?
In that event, your lordship can remand the matter for hearing the writ
All
petition on
right,
merit.
but we have to set aside that order for purpose of
Yes,
remand.
yes.
Do you agree?
No, question of any agreement.
No,
your
no,
lordship, but-
otherwise we have to issue notice, you have to formally we have to formally hear you.
Now, this is, I only support the honorable court's view, but honorable
On the
court
basis
has
of-
not
suppose-
gone into the merit of the case.
No, suppose what the petitioner gains by suppression. Suppression must be for gaining something.
Any material facts.
Huh,
But
otherwise
filing
it
of
is
a case
irrelevant
against
in
a
the
dead person,
Huh?
that is the view, the honorable court has taken a serious view because you filed a writ petition against a dead person. By the time you file the writ petition, you are aware of the fact that opposite party number 2 is dead. That is the only technicality by you. Your lordship will feel that
Yes,
this matter should be hard on merit.
Mukherjee,
Yes, my lord.
how this can happen in a court that you knew some person is no
No,
more?
I did not know. In fact, after I filed the writ petition, I filed a substitution application saying that I have learned that he has passed away.
What is a specific case number has been given by the learned single judge where yourself has averred that the disclosure, this case number such and such.
Yes, that miscase is there on record. Your lordship may see it.
No, it's all right. Whether in the miscase you have stated that you are aware of the death.
No, never.
Do you have a copy of the miscase?
The copy of the miscase must be there on the record.
Your
that
lordship
miscase-
will see, only thing I want to submit, in the first portion of the impugned order, the substitution was allowed. That is the only thing which I find. In the first portion, the substitution was allowed. In the second part, one substitution is allowed. Honorable court ought to have proceed on the merit of it. That is my respectful submission to your lordships. So on the second part of the order says that you have
Have
filed.
you arranged the copy of the writ petition?
Fair submission.
May remand it for hearing on
File
merit
also
with a
the
time bound
this application is
manner.
not here.
The writ petition was admitted. Notices were issued in writ petition on 10th of March 2003. The substitution application was filed much thereafter
We
on
have a
24th
copy of the
of November.
miscellaneous application because we are not getting, because it's not attached to the writ petition. We have a copy.
I have a
Not
copy.
right now, but it is on record because the writ petition has been
We have
attached
the
to
writ
record.
petition record. Let's see. It is item 6. Is this we are checking again? Oh, yes, yes.
What was the number of the IA?
I 111
Double one?
908 of 2003.
Not there.
Actually, this impression has been created by the words in the meantime. What does it in the meantime?
In
Simple
fact, date has been given, but if your lordship sees the date
No,
of
no, come, the para 3 says in the meantime.
yes,
of
yes,
this
my
part
lord.
number 2
It,
is a
it has
very
not been
stupid
very happily worded. It has not been very happily worded.
Exactly, so. So,
That is why it has been allowed.
But the fact of the
so
matter is
heard Mr. G. Mukherjee and Senior Counsel, estate by NSK Banerjee and Counsel for the appellant, as well as Mr. D.K. Mohanty and additional government advocate appearing for the respondents. By means of this intra-court appeal, the order dated 11/11/2022 delivered in WPC number 475 of 2003 has been challenged. It appears from the said order dated that solely on the ground that petitioner instituted the writ petition being WPC number 475 of 2003 against the opposite party number 2 who died before the date of institution. Stop. We have inquired from the counsel for the parties and also perused the amendment made in para 3 of Miss Case number 11908 of 2003. The said amendment doesn't state that the writ petitioner was aware of the death of the opposite party number 2 before institution of the aware of the death of the opposite party number 2 before institution of the writ petition. It further appears from the said order that Mr. P. Behera along with Mr. D.K. Misro, Learned Counsel, have appeared for the legal representative of the opposite party number 2. Stop. Even the counsel for the petitioner has been directed to file the detailed cost title. Stop. We have reason to believe the said order indicate to substitution of the alerts of opposite party number 2. However, since the order is not very clear, we will not draw any inference in this regard. We do not find there is any foundation to hold that the writ petitioner was aware of the death of the opposite party number 2 before institution of the writ petition. Hence, we are constrained to interfere with the said order dated 11/11/2022. So accordingly, the said order stands set aside. But in the circumstances of the case, we would like to remand the case to the single judge for examining the issues as raised in the writ petition on its merit. So, in terms of the above, this appeal stands allowed and disposed of.
Obliged.
Better to withdraw the writ appeal, my lord.
Have you filed any memo?
I'll file in course of the day, my lord.
All right.
There was an interim order.
So we are on the basis of your statement, we are recording that you have filed a memo of appearance. Unless it is filed, you will not sign the order.
I'll file it in course of the day. My junior is indisposed. I'll go and file.
Gathal and
My
counsel.
lord, there is an interim order dated 20th April. And direction was given to the appellant to deposit certain amount.
Subject to that.
Whether we
Yes,
can
he can withdraw the appeal.
just withdraw whatever the consequence that will follow, Mr.
That will
Mohanty.
follow.
Because it is his right that I will not just pursue my appeal. No court can stop it.
Interim order, yes, ma'am.
And everything will be vacated with the withdrawal order.
No, interim order is against the petitioner.
Him, okay.
That is what I am saying.
No,
So-
The request of Mr. Sanjeev
He has
Vidgatal
to
and
deposit
counsel
a
appearing
huge
to the
revenue.
appellant. Mr. Sanjeev Vidgatal and counsel appearing to the appellant has submitted that the appellant is for the appellant is a memorandum seeking leave of this court to withdraw the appeal has been filed. He asked for granting the leave. We do not find any impediment in granting such leave, allowing the appellant to withdraw the appeal. Stop. In view of the above, the appeal stands dismissed as withdrawn. Mr. D.K. Mohanty, additional government advocate, has appeared for the respondent. So Mr. Mohanty has stopped for the withdrawal. Just all right now, stop here. You filed the memorandum, Mr. Udgata?
Yes, my lord.
Item 11.
Obliged, my lord.
11 kindly pass over. Pass over.
In that case, let it come next week because we have some of the matters.
All right. So you come whenever both of you come and make a mention, we'll take up the matter. Yeah.
Item 12.
Minor has picked up, say, 3 matters are there. I did.
All right. Item 11, 12, and 13. Which are these matter? 11? 12,
11, 12, 13.
13.
Three
Okay.
matters.
Call 14.
Item 14.
Minors have fixed up a date.
Is a Passover or
Passover matter.
Minors,
adjournment?
Passover
I
matter.
got some part of that also. I wanted it.
So can it be on 21st of July?
Yes.
Tomorrow matter.
Tomorrow, this court will not be available. If you want tomorrow, it will go to other available bench. You can try there. Why are you taking the adjournment today, Mr. Counsel?
No, I'm not adjourning, madam. I'm just passing over the matter. Mr. Das is on legs, man. Court number 2.
But you agreed when the request was made for the adjournment. What do you want to tell us? We have no difficulty. We can pass over the matter.
Can pass over.
All right, let it come today. Let us see. All right, pass over. 14.
Item 14.
Where is Mr. Pandit? None appears when the matter is followed. Let the matter be listed on 6th July. When? 20th July 2023. It's made absolutely clear if on that day there is no representation from the appellant, will be constrained to pass an order for non-prosecution.
Item 15.
Mr. Panda, we have passed order.
Sorry, sir, extremely sorry.
We have already passed order. It will come on 20th July. Yes. On 21st of July 2023. It is made absolutely clear if on that day there is no representation for the petitioner, we proceeded to pass an order of non-prosecution. You are appearing?
For opposite party numbers 1, 2, and 3.
Mr. D. Naik, Lanesh, Government Advocate, appears for the opposite parties number 1, 2, and 3. Next.
16,
The same matter in the all matters are similar. You are appearing in all the matters, Mr. Naik?
15, all the connected matters are similar.
Are there connected matters? We are fixing on the same date.
My lord.
Same order, just replicate, huh? Yes,
16,
16 same order. You are also there in 16,
My lord.
all 17.
17,
Yes,
Made please your lordship. Lords, here the petitioner has filed this similar petitioner which is a lawyer of this honorable court. Filed this PIL lords challenging this.
My lord, may I please?
yes.
PIL, my lord, petitioners are villagers of Aurora, Nischanta and Kolo, my lord, have filed this writ application, my lord, challenging the inaction on the part of the Tahsildar, OP number 3, in not evicting the OP number 4, my lord, who has constructed a house over the village road and some person over the non which cannot be, my lord. In spite of several efforts, my lord, no action has yet been taken by the Tahsildar.
Mr. Mohanty, take instruction. How
after that every teacher appointed or in position as on the 31st March 2015 who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 4 years
yes.
from the date of commencement of the Right of Children to Free and Compulsory Education Act 2017. Your lordship, that means from 2015 till 2019, 4 years of relaxation. Your lordship, in the recent amendment that is in 8/3/2019, your lordship kindly have a glance.
Where have you quoted?
Your lordship,
Where have you quoted?
in my petition,
Ah,
your lordship.
in para 5, you have quoted section 23.
Yes, your lordship.
And what is the amendment?
Your lordship, kindly have a glance in page 7, that is para 7.
Yes.
That is-
You are referring to the state rules.
Pardon, your lordship?
You are referring to the state rules.
Yes, your lordship. Which is violating this act, central act.
How?
This provides, your lordship, by giving relaxation to the teachers. That is provided that the teachers appointed against the advertisements published prior to 11/2/2011 are exempted from passing OTT. That is, which is clear violation of section 23 of Right of Children Education Act.
You are Mr.
Avinash Swai.
Heard Mr. Avinash Swai and counsel appearing for the petitioner. Serious allegation has been made. In this petition. While framing while amending the Orissa elementary education within the method of recruitment and condition of service of teachers and officers within close the bracket rules 2019. By rule 15(1), within a small d. Some new clauses have been incorporated, which according to the petitioner strengthens country to the right of children to Free and Compulsory Education Act 2009, a central act. Stop. Admit, issue notice, Says Mr. M.K. Kuntiya.
Lordship, I have also filed an IA.
Just wait. Just wait. Let me first issue the notice, then come to the IA.
Yes, Your Lordship. Sorry, Your Lordship.
Government advocate. Asian government advocate. APS and WIPS notice for opposite parties number
1 and 2.
all opposite parties. No formal notice is called for. Do you need an additional copy?
None.
One additional
One.
copy. One additional copy be supplied to Mr. Kuntiya by Mr. Swain and Council by tomorrow. The notice is made returnable on August 2nd August? 2nd August 2023.
My lord.
2nd August.
My lord.
What is your interim prayer?
Your Lordship, interim prayer is to, it shall not be given effect. So far as
This is the very understanding of law that if the rules is framed by the competent.
But they are
body,
preparing gradation list so far as the promotion is concerned.
everything.
So
all
the
all
petitioners,
heard Mr. A. Swain and counsel appearing for the applicant, also Mr. M.K. Kuntiya and counsel appearing for the opposite parties. By means of this application, the petitioner is asked this court to stay the operation of the amendment that has been carried out in carried out by the notification dated 8/3/2019.
yes, Your Lordship.
In the Orissa Elementary Education, the same Act 2019, by inserting Rule 15(1)D of the to stay the operation of the just before the amendment of the same rules, said rules. Stop. It has been apprehended that by operation of the said rules, the promotions can be made to the higher level of the teachers.
Yes, Your Lordship.
Stop. Following the settled principles that the constitutionality of a rule shall be presumed unless it is shown that such rule has been enacted by a person without having any competence. We are unable to stay the said amendment by an omnibus order of stay. However, we would observe that any promotions made during pendency of this writ petition will be subject to the outcome of the writ petition.
Pleasure, Lordship.
In terms of the above, this central career applications stands disposed of.
Pleasure, Lordship.
24. My lord, in this case, I'm challenging inaction of the collector, my lord, who is not supplying the power supply through solar panel for drinking water. Last occasion, coordinate bench of this honorable court director for instruction.
Yes.
Asked order, Your Lordship will see that.
It was before the vacation bench,
Vacation.
a public interest litigation.
For my lord, I have taken the averment that the one community health center is exist at Bhandari Pokhari. Mubarakpur and the distance of Mubarakpur and Bhandari Pokhari is 2.5 kilometers. But the Patuli to Bhandari Pokhari is 7 kilometers. My lord.
No, we are not concerned. We are concerned about what is the distance between the Patoli and Mubarakpur.
My lord,
That you have not stated anywhere, but you are challenging the shifting of the community.
Shifting on the ground, my lord, that the Mubarakpur, the villagers of the Mubarakpur are benefited the medical treatment in the community health center at Bhandari Pokhari, because the community health center Bhandari Pokhari to Mubarakpur.
All right.
And I have made representation, my lord, before the
Heard Mr. SSK Naik, Land Council, appearing to the petitioner. By means of the public interest litigation, the petitioners have challenged the decision of the government to shift the community health subcenter of Patuli to the village, to village Mubarakpur under the same district. Issue notice. Since Mr. Mohanty or Mr. Patnaik, you are appearing.
Yes.
Since Mr. JP Patnaik, government advocate, appears in his notice for the opposite parties, no formal notices called for. One additional copy will suffice.
Yes.
One
Yes,
additional
madam.
copy of the writ petition is supplied by Mr. Naik to Mr. Patnaik, Land Government Advocate, in the course of the day. So notice is made returnable on 2nd of August.
My lord.
And just to have a discussion with the concerned authority, because he says there is a 2 kilometers distance from Mubarakpur.
We have
and
to,
the
we have to
other-
also give notice to the other, the present beneficiary. Mubarakpur also, they must have made
The
a.
master will say, but we cannot give the notice because to whom to serve the notice.
No, we have to give.
You
Now
have
we
a
have.
consultation.
Yes.
Find
Consultation.
out these are not to be matters to be taken to
Yes,
by
madam.
us.
There must be some other
Ultimately, we'll
consideration.
ask for a public hearing and decide the matter.
Yes.
All right. Stop. By the time the opposite party shall file an affidavit. Just affidavit by highlighting what necessitated shifting of this said community subcenter. Said community health subcenter. Stop. 2nd of August.
Oh, bless me. My lord, can I pray for interim prayer, my lord? Can I pray for interim prayer?
Nothing as interim there because government advocate is accepting notice.
Oh, bless me.
It is not an adversarial litigation. Don't take the public interest litigation as the adversarial litigation that someone is, government is for you only. We are just pushing them, take a right decision and which is beneficial for the larger community takes such decision. All right.
Oh, bless. Oh, bless.
26.
May I please, your lords? My lord, this is a case where the villagers of Suhagpur under Puri district has filed the writ application for the encroachment of government land measuring 6.22 acre, my lord, by the open over 5 to 8, my lord. There 5 to 8 are one family, my lord. Even though they have vast land in their village.
Were these opposite parties number 5 to 8?
They are private party only belong to one family, my lord.
All right.
They have encroached the inter plot number 462.
Current council, a very simple question first.
Yes, ma'am.
That you are seeking eviction from the private parties from your.
From government land, well. The Gochar Kisama land, well.
All right. And the government doesn't have any interest.
And we have made a representation to the collector or Tawsilar, everything, well. Everyone we have submitted a representation, but no action has been taken, well.
You want the government to be popular in the election year by evicting their private individuals from the government land. Issuing notice, just think what is there. Simply issuing this, give a status before us, what is happening there. This is not a public interest litigation, I find.
Your lordship, because these type of cases will come in a vast manner. Your lordship may issue notice, I will file the status report. But if your lordship wants that he should get this PD justice,
Because
your
we are
lordship will
issuing,
direct the
no,
Tawsil
because
man.
you are issuing notice only because the land belongs to the government.
Yes, that is what I am saying, my lord. Your lordship may kindly hear me.
Just you say what is your stand, that's
Yes.
all. We will
No,
close the
your
writ
lordship,
petition.
if it is a government land, Tawsildar ought to have his.
Exactly, that is why.
Encroachment. So that is
Because
why.
you are the custodian of the, this is the, on public trust, you are the custodian of the land. Ultimately, it is for the public interest.
Yes, that is.
If you allow
but-
people to the trespassers and these squatters to allow all the government streets and land, then the public life will be very precarious. So that's why, that is the.
That is why your lordship
All
is
right.
issuing the notice. I will file the status report.
You are Mr. Rajguru?
Yes.
Mr. KC, heard Mr. KC Rajguru Land Council appearing to the petitioners. Stop the petitioners have them has filed this public interest litigation. seeking evictions of the squatters. Opposite party number 5 to 8 over the government land as described in the Annexure 1, which is the ROR stuff. Issue notice since Mr. B.K. Mohanty and Council appears in Whip's notice for the opposite parties number 1, 2, 3, and 4. No formal notice in respect of those opposite parties is called for. However, Mr. Rajguru and Council shall supply 2 additional copies of the writ petitions to Mr. Mohanty by tomorrow. That apart, steps shall be taken for service of notice on the opposite parties number 5, 6, 7, and 8 by registered post with AD within 3 days from today. Well, it says the notice is returnable on 2nd August.
2nd August.
27.
On behalf of Mr. Mahant, will take up next week.
The matter will be listed on. You are Mr. Sarathi Jati Mohanty.
No, I am Mr. Ramesh Kumar Sahu. I am on behalf of Mr. Mahant.
Ramesh Kumar Sahu.
Yes, ma'am.
At the request of Mr. Ramesh Kumar Sahu, Learned Counsel, appearing on instruction of Mr. S.J. Mohanty, Learned Counsel for the petition, let the matter be listed on 21st of July 2023. Yes.
28.
May I please, your lordship? Here it is similar to item 26, what your lordship was observing. Here it is a case in Cuttack town. It is enclosed by several persons, including the OP number 6 to 10. Lordship, they have opened.
On 2nd August 2023, since Mr. B.K. Mohanty, National Government Advocate, appears in Whip's notice for the opposite party. This is called for. However, Mr. Suhail and Council shall supply 3 additional copies.
I can appear for opposite part number 2 to 9, 8, 10, and 12.
2 to 8.
8.
And 9 you are not.
No.
This is a government program.
Yes, Your Lordship. It's a state government program.
Because it is under the SC/ST
Yes.
9.
2 to 10.
10 also.
11 also.
Accept 11 and 11 you cannot, but all you can accept.
If there is a batch of writ petition,
Yes, yes.
and along with the batch of petition, also already hired my lord WPC number 34769. So kindly see the order dated 24th April. So
34769.
My lord, that was then directed to be the lead case, and Mr. Rautre from Senior Counsel was arguing that matter.
Yes, yes.
On 24th 4, it was had in part and also directed to be listed on 2/5 at 2 p.m. But on that day, the bench was not functioning.
Today, Mr. Rautre is not available.
Because as per the noting manner, supposed to be taken on 2 p.m. He was there. If you also take up at 2 p.m. or you also take up any other day.
No. It is fixed for 2 p.m. Lordship. As per this order.
That's WPC number 34769.
Is it fixed at 2 p.m.?
2. Another matter. This is the also kindly see the order. In the 20th sub item, my lord.
No, you are referring to 24/4 to the 23 order.
My lord. Because the order was passed in the lead case, that is WPC number 34769. Also kindly have a glance to the order, my lord. No, that's right.
It appears it is partly heard by us.
My lord. Yes, yes.
Are you ready today?
I am ready.
You are also ready.
Lordship, we are ready.
At 2 p.m. Mr. Raut is supposed to argue because he was arguing the last occasion.
All right, we will deferring the matter to 2 p.m. 2 p.m. on actually date was fixed on 2/5. For that it was 2 p.m. But for today anyway, we will accommodate you. Come after the post-lunch session. Come in the And the first part was the personal appearance.
Personal appearance item 68.
Just ask whether someone is there.
ଆଉ ଜଣେ ବସିଛନ୍ତି ଆଳୁ ବାବୁ।
No order has been passed as yet because you have not filed the certified copy.
Already certified copy filed today.
Ah.
Annexure 1, 2, and 3. Let this matter on next week only, I pray.
All right. You are Mr. Patnaik.
PK Mohanty.
At the request of Mr. PK Mohanty, Learned Council, appearing for the revision petitioner, let the matter be listed on 21st of July 2023. Mr. Mohanty, Learned Council has reported the certified copies of the annexures 1, 2, and 3
Already
have already been filed
today.
Today, the list is directed to compile those records. To compile those copies with the record. All right. Just call 38.
38.
My lord, for a small mistake.
Mr. Rao, we are facing a difficulty. Very young.
What I suggest, because you are sitting absent tomorrow, because it was argued it was. And I continue.
Is the mic on, Mr. Rautra? We can't hear actually.
Hello.
Yes.
So 36 you also fixed it at 2 o'clock. And it matter was hard also the last occasion.
Now,
Of
there's
course,
one matter you argued that. we
Yes,
have
yes.
taken.
So what I suggest to her, my lord friends are there also. If you are will absent tomorrow, why not it will be kept on 4th so that we can continue within a day or two. I'll only take 2 hours, 1 or 2 hours. Because large number of cases will be covered by that.
Another
Say
best
2
matter is
PM,
there.
you must fix up in it.
All right, we'll fixing on 4.
Yes, my,
All right. We'll pass the order when the turn will come, we'll pass the.
my.
That is only
Council
Mr.
may
Ja-
be, we'll pass.
Yes,
the
yes.
only 36, sir.
36 all back,
All batch.
There's another one also, I think. 38.
Another one, Mr.
38.
No, no.
Just find out and inform us so that both can go to the same date.
38 that board matter.
Oh, that is different.
Board
Okay,
matter,
okay.
yes.
Sorry.
Only
One more
36.
something was there. Okay.
I mean, pardon to mention, my lord.
No, wait.
Ah.
Ah.
Yes.
No.
That is a personal appearance, my lord. Also added at item 68, my lord.
All right, you asked it to whether they have appeared.
Are they there? We were looking for the parties before lunch.
That
but-
have come.
All right.
Yes,
68.
also certain from the IIC that they have come, but their mobile. The council.
Minutes is a courtroom, let them, because the other matters is very urgent.
And Mr. Mahanti, where is
Sir,
Mr. Mahanti?
like be there on screen.
Mr. Mahanti is not there. So how will we take it up unnecessary?
Special notice item 1, WA 303/23.
Mr.
Please, my lords.
Urgency, you yourself had adjourned the matter in the month of May to August. Item 1.
My lord, there is a preponement application therefore pending because the contempt application came up, therefore I was constrained to mention. Because
When is the
current-
contempt application posted to?
All
It was there on yesterday. Now I think it must have been posted to some
All
other.
right.
But this is a matter. I'll just give a brief.
Come
context of the
straight to the
fact.
judgment.
My lords.
Come straight to the judgment.
My lords. Page 105, the portion that I am placing before my lords is page 109.
Yes. Yes.
My lords will see para 11.
Para 11, the learned single judge has said that in view of such stand taken by the learned counsel for the parties, and in view of the benefit extended in favor of similarly situated persons with having similar sports certificate in Balasore district, this court directs the opposite parties to consider the claim of the petitioner in the light of the decision taken by the authorities of Balasore district. The very next paragraph, my lord, will see. Since in the proceeding of the meeting held on 18/11/2019, one post has been kept reserved for the petitioner, it is observed that the opposite parties may fill up the said post by providing appointment to the petitioner. So para 11 talks about consideration and para 12 is a clear direction to give appointment.
Okay.
The reason, my lord,
Just take down. Heard Mr. D. Naik, additional government advocate appearing for the appellant. By this intercourt appeal, the judgment dated 13/5/2020, delivered in WPC within bracket OSC number 2685 of 2016. Mr. Naik and counsel is appearing for the petitioner has stated that the paras 11 and 12 are mutually contradictory. In para 12, the learned single judge is directed to appoint the petitioners against the post as was kept vacant by an order passed in the proceeding. But in para 11, there is a direction only to consider the claim of the petitioner on the basis of a post certificate. Stop, admit, call for the records of WPC number such and such. 268 of 2017. WPC, huh? Stop. Issue notice. Notice is made returnable on first 22/8. The next date of the case. Yes. The next date was on 22/8.
2020.
Same thing. Ah, 22/8. Ah. Just beginning, huh? Hard session, before Mr. Naik's name appears, this matter has been taken up on special notice. As it has been mentioned before us, the contempt proceeding has been initiated against the appellants.
I should have brought it to my lord's notice. There's a 249 days delay in this application. There's a delay. There's a petition for condemnation of delay that is filed. There's a delay.
Stay. This matter.
Two IAs, one for condemnation of delay, one for stay of the operation of the order.
No, that we can have.
It's IA 764.
Just score out. Score out this order, huh? That will not be there. This matter is taken up on special mention made by Mr. D.K. Naik and counsel. Where is that application?
That the registry is not marked here.
2303, no? That page? Or A?
Flag the A.
But here is no flag.
The screen one.
That's it is.
Yellow one.
This 764 of 2020, huh? Heard Mr. D. Naik and counsel appearing for the applicant. Step. There's an application for continuing the delay. What is the delay? That is the.
It's 249 days. 764. IA number.
Oh, this time to yes. 252 days. In filing the intercourt appeal from the order dated 13/5/22. Was by the learned single judge in WPC OSC number 2685 of 2017. So, issue notice as to why the aforementioned delay, huh? Just formatted. Notice is made returnable on 22nd August 2023. Steps for service on the opposite party.
May I prefer shorter returnable date if possible, if possible.
We'll grant stay. Think over this prayer.
My lord, I heard August, my mistake.
No, it is August, but you are getting an interim order, so you
Oh,
want
my
to
lord.
see that.
Because in out of turn, we'll be granting it
My lord.
because of
I'm
the nature of the
I am
order. By its response on the respondent. Respondents, by within 3 days, register post with AD. Stop. In IA, this 765, same way, this one mentioned taken up. Heard Mr. Citizens such, there is an application for staying the operation of the judgment dated 13/5/2020, delivered in WPC OSC number 2685 of 2017. Then this is what I dictated, the mutually destructive, stop, in consideration thereof, as a measure of urgency, stay the further operation of the as a stop, no, so the issue notice as to why the stay as sought for will not be granted till disposal of the connected should not be granted. Notice is made returnable on the same date. Meanwhile, meanwhile, the judgment dated 13/5/2020, operation of the judgment dated 13/5/2020, delivered in WBC OSC number 2685 of 2017, shall remain suspended. Right. The code that part I dictated earlier in the writ petition, it is in there still. Always.
Item 2 WA 1377/23.
May I please?
Yes.
Let me turn to page 41. Impugn order.
What happened in this case? Why the urgency?
There is a contempt has been filed.
Contempt petition has been filed.
Yes, my lord. Contempt has been filed. Personal appearance has been given. Direction has been given for person on 30th June.
Why did you assure that the order will be complied with?
My lord,
You have assured the court that the order will be complied with?
no, why, your lordship is that page 41.
No, page 9, that. The annexure to the IA. For stay.
In contempt case, you have made a solemn pledge that you will comply the order of the court. Come to that order page, this is IA. 9 in the IA.
We have complied the order.
So.
No, but the thing is the AGA has appeared and some standing counsel has assured. No.
What has happened, my lord? Your lordship, for a moment, your lordship see that order.
Let me read the order.
The AGA has appeared by the standing
Yes,
counsel.
I am reading out. List this matter on 30th June 2023 is filed for by the learned additional standing council to comply with the order of this court. If further issues that the order shall be complied with by the next date.
What has happened, my lord?
Now, whatever happened, this we a different case that you after making a solemn place before a court, you are now just turning.
The original order basing on which this order has been passed, that has been stayed by my lords.
Which order?
That I am bringing my lord's notice. Page 41, your lordship may see.
So could that not be brought to the notice of the court?
It's page 41. Come to
Yes,
the page
your lordship may see. That order has been passed relying the judgment order dated 23/11/2021, passed in WPC number 16906 of 2020. That is the subject matter of challenge in WA 127 of 2021.
No, whether those judgments or these other judgments in analogous matters are stayed by this court.
Yes, ma'am.
When?
Page 43.
Page 14.
That I have given that copy of that order, and that has been fixed to 8th August.
So if that has been stayed, could you not bring to the notice of the court
Yes, ma'am, that should
when the matter was taken up on 12/5/2023?
yes, ma'am, that should have been brought to the notice of.
Yes. So do it. Ask for recall of the order. So many counsel.
So earlier order was stated, now this shall be kept in abeyance, right there. Yes, heard Mr. MK Kantial on it. There is no delay, I think, in this matter.
Yes, there is a delay of 370 days. I filed a prior to that extent.
Appearing to the applicant. So, I number 3606, this is an application, same way, na, condonation. Section 5 of the Limitation Act for continuing the delay of 457 days and preferring appeal against the order.
Which page is the order?
Order is 16/2/2022.
Page is the order.
Page 40, 43, 41. Some period will be excluded, that COVID
From
period.
the order dated 24/2/2022 as delivered in WPC OSC number 624 of 2013. So issue notice, same way. When it was fixed for
8th August. That matter is fixed to 8th August.
22nd August 2023. States for service agency, same code, the same way. Next, another is the flag B. There's an application such and such. Line number 3607. Heard Mr. MK Kantial, counsel appearing for the already on special notice. Appearing for the applicant. There's an application for staying the operation of the order date 24/2/2020. 22 passed in WPC OSC number 624 of 2013. All right, Mr. Kantial and counsel has submitted that the order dated 24/2/2022 has been passed basing on the order passed in the WPC number, basing on the judgment and order dated 23/11/2021, passed in WPC number 16906 of 2020 and common judgment, that's right, and WPC number 18877 of 2021. So, Mr. Kantial and counsel has submitted that by the order dated 16/2/2022, delivered in WA number 127 of 2022, this court has this court has as an interim measure directed to the operative portion of the said judgment dated 23/11/2011. What is this? Dated 23/11/2011.
21.
No, this judgment in the order. No, here.
Sorry, my lord.
Have you seen that order? When
Yeah.
the operation of the order has been stayed, look at the date of the order mentioned in the order.
It should be 21, I think.
No, my 16/2/2022.
No, just come to this page 43.
My lord. That is 16/2/2022.
Just below, this come as an interim measure, the operative portion of the judgment dated 23/11/2011. We have nothing to do with the judgment.
yes, my 23/11/2008. Sorry, my sorry. That
So you are not taking any care. Why should you give the relief in equity to you?
that 2000 that has been written at 2011. Sorry, I have not seen that 2011. Yes, ma'am. That is 2021 instead of 2021. That has been
23/11/2021. That is the single judge.
Yes.
In WPC number 1606 of 2020 has been kept in abeyance till the next date. According to Mr. Kuntia, the said order has been continuing. So, having regard to that aspect of the matter, having regard to that fact, as an interim measure, we keep the impugned order dated 16/2/2022 in abeyance till the next date. Issue notice is not there. Notice has been issued. Steps also. Take step within 3 days.
By tomorrow.
A notice is made returnable on 22/8, earlier one, 22/8/2023.
Public.
Urgent certified copies. Yes. Is agreed by the council to the parties. That is first order, Let this matter be posted, let this matter be listed on 4th of July. As parted for hearing. Just reflect the name of the council, sir. Yeah, Mr. Biswal, you just kindly just prepare a short slip of the appearance.
My lord.
So that it can be reflected in the order.
Yes, sir.
4th July.
My lord.
Mr. Naik, you are appearing in all the cases.
In all the cases for this.
Mr. D Naik for the opposite parties. A petitioner's name will get, Yes.
Item 57.
May I please, your lordship?
Yes.
Item 39, may I please? 80 days delay for filing the writ appeal.
8 days. Who is appearing?
Is there any private party, only the government?
My lord, government.
Who is appearing for the state in this matter? Any objection?
The only, so far as merit of the case is concerned, whether my
You are Mr. Lenka.
Controller of accounts.
whether a lawyer can surrender or conclude substantial legal right of client without instruction of the and the Supreme Court, my lord. The lawyer does not press the matter so far as annexure 1, 2, 3 is concerned. And the Honorable Supreme Court, my lord,
First, just let us dispose of this, your interlocutory application for continuing the delay.
8 days delay, only 8 days delay.
Mr. Kuntiya, can we condone the delay?
Yes, ma'am.
All right. Heard Mr. Dr. Jitendra Kumar Lenka, learned counsel appearing for the applicant, I-3295. So this is an application for continuing the delay of 8 days in filing the intercourt appeal against the judgment dated 9/9/2022 delivered in WPC OSC number 1037/2017. Stop. Mr. M.K. Kuntial, an additional government advocate appearing with the opposite parties, has submitted that state has no opposition if the delay is condoned. We have perused the causes assigned in the application and of the view that the delay can be condoned. So accordingly, it is ordered. The result, this application stands allowed and disposed of. Come to the appeal. Appeal would be in some other day. That is why I'm not admitting it. In the appeal, in view of the order passed today in such and such, but the appeal will be listed for admission on 10th of July. It's already 10th of July. Next.
Item 40.
But in this appeal, there is 29 days of delay.
Only the government is a party.
Government is a party, private party is my Lord and Senior is the
I have
applicant also.
appeals to
Respondent 3. So I think there may not be any objection. I have.
So you have arranged with him that he will not raise objection.
I have already.
So
talked to
you are not opposing the prayer for delay.
No objection.
delay, I am not opposing.
39 days delay.
No, read appeal.
Yes, delay will be condoned, I think.
Read appeal copy has not been solved.
Yes, I will solve. I'll solve.
I-3359 of 2022. This is an application for condoning the delay of 49 days in preparing the intercourt appeal against the order dated 11/8/2022 delivered in WPC number 9746 of 2017 by the learned single judge. So, Mr. Dr. P. Chuli, learned counsel, has appeared for the applicant and stated that delay has been explained in Paris 4, 5, 4 and 5. So, Mr. M.K. Kuntial, and Central Government Advocate, appearing for the opposite party, number 1, 2, and Mr. Mr. S. Mollik, Learned Counsel, appearing for the opposite party, number 3, is submitted that these opposite parties will not oppose the prayer for the condonation of delay. So in view of the above, we condone the delay as the person mentioned. The result is application stands allowed. Stop. Admission matters some other day. In view of the order passed in I number such and such, let state for admission on 10th. After that, 27. 27? No, this is an admission matters. 20th July, 2023.
Yeah.
Yes.
41.
41, your lordships, the noting shows that steps of limitations not taken. Actually, your lordships, there is no limit, issue of limitation in this matter. We have explained that at page.
According to the stamp reporting, it is 14 days.
Lordship, it's faulty because it did not take into consideration my para 4. That's page 7. We have applied on 16/11/2022 itself on the day the judgment was passed, but there was a delay in receiving in supplying us the certified copy.
Supply, you are not concerned when the certificate.
When you apply for urgent certified copy, the date of stamping is not there. This is the problem.
No, that's why your lordships, we procured also a copy of the day we applied. So therefore, your lordships, actually the copy was given to us on 22nd/12.
That is fine, but when did you apply?
The very day the judgment, your lordship, 16,
That is
11.
there. That is there on the copy.
Yeah, lordship, we did provide the copy.
It must be here.
Yes, and we had taken a pleading to that effect. No, your lordship, we didn't.
When the certified copy was ready, that is the issue.
Yes, on 22nd/12/2022.
How do you say that? On the basis of what document?
So certified copy, the very certified copy backside will show your lordships.
No, had you not annexed a copy, the certified copy?
The first copy.
Then it must be there.
The backside of the certified copy will show it.
Where is it? Page.
Just to see, bring the physical copy, it may not be scanned.
First copy that is first date of the
It will be behind 250.
Common judgment 223. Behind 252.
Yes. Last.
Okay.
And your lordship, we have this copy also when we applied for the certified copy.
Date of application.
It was applied in the court itself, your lordship.
Date of application says 3/12.
Yes.
Date of ready is 2022.
That's why your lordships, we brought this, the date of application.
No. Now if you get it, if it's not there, how will the stamp reporter know while preparing the stamp report?
That's the reason why we had explained everything at para 4.
But is he supposed to read the limitation petition and condone your delay while preparing the stamp report? He does it as per the thing. If there is no delay, you can explain it while filing a petition.
That's why, no, there is no delay. That's why,
Unless it is obvious,
Yeah,
he will not, he will point out there's a delay, but you have an explanation. That maybe an application may be necessary, but because if he reads the application, then the stamp reporting will take ages.
Sometimes they do, sometimes
they do it.
Sometimes they ask us, explain us, but sometimes they don't. And your lordship, the other defect is that we are actually supposed to provide translated copies, your lordship. Odia. It'll take us some time.
All right, we are adjourning the matter. 20th of July.
Lordship, may just that limitation defect may be just ignored.
Cannot you file an affidavit, short affidavit?
Either an IA or
Because that something should be on record when the stamp reporter has sent. We must replace this affidavit, 2-pager affidavit, explain what you have submitted
Lordship will
before
do
us.
that. Yes, because the appeal normally doesn't come with an affidavit, so I will provide that.
The request of Ms.
Appeal affidavit are not signed.
Learned counsel appearing for the appellant. Let the matter be listed on 20th July 2023. Meanwhile, the steps is required to be taken by the appellant shall be taken.
42 and 43 arose out of the same judgment, same defects have been pointed out. So you'll
Same order?
Same.
20th,
Same.
Let that come in one serial.
Same explanation.
Same judgment.
No. Like she said, she has explained everything. Have you explained?
Yes.
You have also explained.
Yes.
Which date?
20th July.
44.
A common judgment, so maybe they can be listed together.
I am appealing for one of
same
the
date.
respondent 44. But copy of the appeal memo has not been served on me. I was the writ petitioner in the court before honorable single judge. And that was allowed. Let him come.
I could not get it. What is your submission?
I will serve a copy, let it come next week so that.
Is it 44, I think?
I am for the appellant, my lord.
Yes.
The judgment has already been implemented.
Implemented.
to, most of the direction of this unknown course, he has been removed from preparing PHS.
Who has implemented the judgment?
Judgment is honorable single judge judgment. That is judgment dated.
And Mr. Mishra, Mr. Mohanty, you are appearing for whom?
I am appearing for, I am appearing for, that copy is not, I am appearing for Ma Saraswati SHG. Ma Saraswati SHG, my lord, who was the petitioner.
Yes, it is where you written a PROC
Samira
on
को matter.
instruction.
Power का नहीं.
Just give a name of the one of the council, no, record. Yes.
I am appearing for Ma Saraswati SHG.
41.
Was read
41,
petitioner.
42, Mr. BB Mahanti was there.
Let a copy be served on me. I
42,
can
50 BB Mahanti.
know that what is my number as the restaurant.
41 you write Pamira.
No, this is problem is that
Pratyashish Mahanti. Khali BB Mahanti, same order. The same order.
The problem might be.
41 day Ms. Pamira on behalf of Pratyashish Mahanti.
you are appearing for the private respondent.
Yes, my lord. I was the read petitioner there.
I understand. How can you say that the appeal is cannot be now admitted?
My lord, that I filed it. I came to know, my lord, that one read petition was filed by, after removal, one read petition was filed by the present appellant. Honorable single judge said, opined that that was not entertained. Find that appeal has been filed by the present appellant. Let to go there. Knowing that, Aji has sought for interim order, therefore.
No, interim order, you may say that it can.
That is correct. I am not.
That only the stay order you can
I-
say that it is
I
already
know that,
implemented, there cannot be the stay of the.
I know
operation.
that, my lord, I know that.
So for the appeal, we can consider whether the judgment
Yes,
is
my lord,
correct or not.
That is correct.
Even you also the order that has been passed implemented, we can in a
That is correct, my
consequence.
lord, I have.
All right.
Copy may be served, my lord, if your loss is.
There is no delay, I think.
No delay, my lord.
I will make you submission when the read appeal will be admitted. What is the order?
That is running page 12, my lord. Impugn order is running page 12 by annexure 1.
Yes. Yes, which was the observation that you were affected by?
That there was an agreement for providing THS Chatua in my favor, and since the selection since 2018, I was supplying till the date of judgment and continuing. But by that order, Honorable Single Judge has stated in Para 8 for reasons aforesaid, impugned engagement order dated 5th October 2018 is set aside and quashed. Consequently, agreement executed pursuant to the engagement order is rendered void. Petitioner may approach the authority concerned for engagement. My humble submission is that if that order of engagement will be quashed, then a fresh tender or fresh advertisement may be made out so that anybody can be participated. And so far,
Now, what is the reasons given for this quashing your engagement order?
that their case was that
Challenging.
that is reflected in Para.
Telling the question. The reasons. is correct.
My lord, Para two of the said order, that is a few days thereafter, on 17th September 2018, the collector along with district social welfare officer DSWO, the CDPO and sub-collector were said to have again inspected available units for procuring Chatua, paragraph 2 and 3 from the reports respectively with the reference to his client and opposite party number 6 are extracted and reproduced below. So far, my learned senior's client is that is number 2, Ma Saraswati SSG. The SSG is situated on Balabhadrapur village, infrastructure and hygienic condition was good. All 12 members were present and the member list has been displayed in the board. Collector asked the members regarding their income granting activities. The grinding machine has been installed. The members told that they are preparing turmeric power, green gram, besan, etc. One educated girl is also coordinating this group. The SSG has availed loan from the bank for preparing the above mentioned items. So for my SSG is concerned, the appellant's SSG, that is Madaneshwar SSG. The SSG is situated in Madanpur village of Madanpur GP. The formation date is 10/5/2004. The infrastructure facility is good and SSG has installed all the machineries such as grinding, roasting, etc. for preparation of chatua, but it is situated in the middle of the village. The collector interacted with the SSG. They told they are preparing turmeric powder, chili powder, BD pampered, body pampered, and also displayed some items. From the discussion, it is ascertained that the SSG has availed 4 lakh loan for installing machineries. They are 13 members out of 8 members belongs to BPL families. He submitted thereupon the opposite party number 6 was engaged by the impugn order dated 5th October 2018, agreement dated 9th October 2018, engaging the opposite party number 6 clearly stipulated as an essential requirement that SSG shall, before signing the contract, provide security deposit of 5% of total value of production taken, take home rotation THR Chatua in a year. The essential condition which was waived, that condition was not been fulfilled by the appellant. That was their allegation, but in their counter, opposite party number 2 to 5 has stated that that is not required. That has been waived out. 2 to 5 are the government parties. They have stated in their counter. That counter also I have.
What has been waived? The security deposit.
5%.
So the writ petition has been allowed not on that ground. It has been allowed because you didn't have a food license.
I have also that food license was not required also. That is one cause, and another is that registered SSG jota 16 page my lord told that SSG is Federation engaged in production of THR come under the purview of FSSAI Act. It is mandatory to ensure the SSG/SSG Federation are registered or licensed as applicable under the FSSAI Act or applicable rules regulation. The SSGs engaged are to display the certificate in the premises of the THR unit. So far that is concerned that 2 to 5 has also stated in their counter that was not required.
No, not required. The thing is as required. So if it is required, even if they say it is not required, it will be required. So you point out that it was not required. Merely they saying in the counter is not helpful to you. If the provisions say you have to have, you have to have.
FSAI is a statutory authority and the creation of an act.
My lord.
Right? When the statute provides something that you cannot do and carry out a particular the food operation, how the person 1, 2 to 5 can waive this requirement?
If the provisions provide it can be waived, then it's all right. So you point out that specific provision if it is there. Because reading of that says that wherever required. So was it required or not?
My humble submission is that is not required. Let it come next week. I will clarify.
No, because this okay, come with this books. Let the matter be listed on 25th July. At the request of you are Mr.
Bikram Chandra Ghade, BC Ghade.
Yes, yes. You are also for the petitioner.
Lead petition there. Section 31 is very much clear.
Bikram Chandra Ghade.
Let him get a chance to satisfy. Let
I
him get a chance.
understand
He's
we have
not
to
gone
satisfy
through.
because we are not admitting the matter, simply adjourning the
Yes,
matter.
my lord, I am.
And counsel is appeared to the appellant. All right.
Mr. Mahanti?
No.
For the
He is not
respondent.
admitted.
No, but he is appearing for the respondent.
I will not record his name.
45.
Item 45, Lordship. I beg pardon. The impugn certified copy of the impugn order passed by the Honorable Single Judge has not been filed. Therefore, the SR couldn't be made. I file by tomorrow. I pay for next week, Lordship.
Let the matter be listed on 10th July 2022. At the request of Miss P. Mohanty and counsel for the appellant. Next.
46.
May I please your lordship? My lords, though there is a limitation of 65 days, my lords, in the instant case, limitation will not apply because my lords, we are the private encroachers. We have been made parties. OP number 4 to 15 have been implemented as opposite party, private parties. My lords, your lordships may kindly see.
Which law provides that the encroachers doesn't have the observe this mandate of the law of limitation?
No, my lords, because your lordships may kindly see impugned order at page 15. In the second para, no notice is issued to opposite party number 4 to 15.
Yes.
As the matter is disposed of at the stage of admission. My lords, the order was passed.
Would come to the order.
21st 3/2023. My lords, we have no knowledge about the order. My lords, while the revenue
Just show that which part is affecting your right.
My lords, we have been directed to be evicted.
No. Order is to expedite disposal of encroachment proceedings. So what is wrong? For that you have to be heard.
How you are affected? That
Paragraph
is
8.
Paragraph 8 you read. Nothing against has been decided against you. They have just remitted the matter to the disposal of these proceeding for eviction. You just whatever you want to say before that.
My lords, encroachment proceeding, namely opposite party number 4 to 15.
Yes.
And ensure their eviction.
Where? Where is it?
My lords, paragraph 8.
Last line.
Last line.
Yes.
Ensure their eviction.
Yes.
That is.
You are right.
4 weeks, within 4 weeks. And eviction has been fixed to 30th. On mic, there was an announcement.
All right. You are Mr. Boy?
My lord.
Heard Mr. Apurish Boy, learned counsel, appealing to the appellant. Stamp reporter has raised
May kindly
objection.
have a glance on the
Just wait.
previous paragraphs of the.
All right, this is a positive mandate without hearing the person will be affected.
That was a previous litigation. That is
Whatever litigation, we are concerned with the present litigation.
concerning the same issue.
Ah.
So the 2824.
No,
that
Mr.
in para 4,
Mahanti,
There was also
if there is an order of eviction, then we can understand if this expedite eviction. But if order has not been passed and it says ensure eviction, how can that be without hearing them?
No, I'm just reading para 4 of the impugned
Yes,
order.
read para 4 of the impugned
Learned
order.
counsel for the petitioner submit that.
Yes, inquiry.
Approach this court on an earlier in so and so, which was disposed of on so and so with a direction to Tahsildar to consider the grievance and after making an inquiry to initiate appropriate action as per provision of law against the unauthorized encroachers and complete the exercise within a period of 2 months. However, it has not been accomplished. It is further submitted that since removal of the inquiry is still awaited and there has been no compliance of the court's order, necessary action may be issued to opposite party note 3 to proceed against it.
So all the more reason that notice should have been issued because the eviction proceeding is not complete.
Yes.
So
So
how can you ask for ensure eviction if they have not been heard?
means he has directed, the honorable single judge has directed the Tahsildar to.
Have you not understood the order? We have also understood the order. It's very clear. Had that last line not been there, then we would not have interfered. Exactly.
That last line.
Yes, exactly. For that, why spend extra 10 minutes?
No. What will be the procedure on court said they ensure their eviction as soon as possible? Where is the proceeding? What is the meaning of the
In the OPLE Act, the honorable court is saying that you have to ensure the eviction in that OPLE matter of the unauthorized.
Ensure disposal, we can
Disposal,
understand.
yes.
Yes, exactly. Simple point.
Disposal.
Yes.
Disposal, whatever the result may be, that should not have been.
No,
Exactly. So
his line
the
is
point
troubling us. They ensure eviction of those parties. That is the troubling line.
State.
Just Hart Session search. Stop. No, just that is this is an intercourt appeal against the order dated 21/3/2023 delivered in WPC number 36448 of 2021. Stop. It has been pointed to us.
Paragraph 8. Paragraph 4.
That in para 2 of the said order, it has been recorded that no notice is issued to opposite party number 4 to 15 as the matter is disposed of at the stage of admission. But in para 8, the learned single judge has made the following observation. Quote, in the result, the writ petition stands disposed of with a direction to opposite party number 3 to expedite the disposal of the encroachment proceeding vis-a-vis the encroachers, namely opposite party number 4 to 15, and ensure their eviction as soon as possible, preferable within a period of 4 weeks from the date of receipt of the copy of this order. This keep the underline, ensure their eviction to the end. Stop. Having noted that direction in absence of the appellants, who were the opposite parties number 4 to 15 in the said writ petition. Stop. The appellants have not afforded any opportunity to defend their right, if any. Stop. In such circumstances, we admit this appeal to be heard on merit. In the counter affidavit, sorry, they will not reflect. We cannot go through the report right now. Stop. Admit sentences to be heard on merit. Issue notice. Returnable on 28 July 2023. Since Mr. D.K. Mohanty, D.K. Mohanty, Learned Counsel, appears in Webb's notice for you give the physical copy, you file someone is correct.
You find out if final orders have been passed. That is why, that is passed, you bring that to the notice.
There may be some error in the impugned order, but. if-
No, so error, so that you have to point out, not that
but
we
if
point
the
out to you.
Tahsildar has already
So what is
finalized
it? What is the meaning of if?
So, no, that I will find out.
Yes.
That I will find out. Then that order would be appealable. That is what I respectfully submit.
Therefore, no formal notice.
Appeal,
is
revision.
for-
There are so many things.
Appeal
So
is
this-
pending, my lord. Appeal
No,
is
no,
pending.
against that encroachment order.
Encroachment order appeal is pending and my
Where
lord,
you have said so.
annexure 2 order gudaku mu deji.
For service of notice
Annexure 2 appeal
on the opposite party.
Yeah,
number
Purun, that is
4,
old.
5, 6,
Now, pursuant to the
8,
honorable
9,
court's
10,
order,
11,
whether
by registered post with
You mean
18,
if court directs for eviction, appeal
By
will not be maintainable?
30th of.
yes, they
June
will pass an order.
2020.
That order is set under the OPL Act and applicable. That is what I
Already made returnable, no? Date is given, notice is returnable, stop. Do you need additional copy? I don't think.
No, I will take instruction, the status, I will
All right.
furnish the status.
No, my lord's status quo may be maintained.
No. That we cannot. You come because there is no.
My lords, they have fixed.
You filed the update because we find in the counter affidavit filed by the state, they have stated already the eviction order has been filed. You filed an appeal. You have to state in an application, what is the status, what is the, whether there is any interim order granted
No,
to
no,
you.
my lords, in appeal, annexure 2, page 18, page 18.
Have you filed appeal against the order of
Yes,
eviction?
yes.
My lord.
Go for the stay of the order to the appellate authority, not to the.
No, my lords, appeal has been admitted.
Ah.
Admitted since in 2009.
File an application there, get it a rejection order, then we can
No,
consider.
my lords, now they are saying, as the Honorable High Court has directed for eviction, we are bound to evict you.
That is all right. This just, have you filed any interim prayer?
My
for
lord,
stay?
IA number 3567.
Status quo as on today, your lordship.
My lords,
As on.
status quo. as on-
That is obvious.
As on. But if they have already been evicted in the meanwhile, so as on today.
My lord.
In I number 3567 of 2023. Part such and such, in both the council, huh? There's an application for eviction of the, for staying the eviction process pursuant to the order dated 21/3/2023 delivered in WPC number 36448/2021. Annexure 1 to the writ appeal being WA number 1365 of 2023. Stop. Issue notice. So in the meanwhile, the status quo of occupation shall be maintained as on today. Stop. The applicant shall take steps. No, since Mr. D.K. Mohanty and Council appears in Webb's notice for D.K. Mohanty appears for the opposite parties number 1, 2, and 3. No formal notice is called for in respect of those respondents. However, the applicant shall take steps for service of notice on the remaining opposite parties by registered post with AD by 30th of June 2023. Take step in the meanwhile. The status quo as until, there is already there.
That already.
27th August. Your lordship is fixing the date to
28th of July.
next 10th of July.
28 July.
And steps have been directed to be taken by the 30th of June.
My lord.
28th July.
My lord's urgent copy.
Urgent copy, yeah. This is
47.
just wherever the interim order is there, type this first and send us. Others we can do.
47, my lord. My lord, there's a
8 August.
delay of 3 days, my lord. There's a delay application which is being there, my lord. IA number 3579,
There's a
it's at
private
flag
property,
B,
it's
my
not
lord.
arbitrage. You could have found out.
But the stamp reporting has not been done.
It might so have happened, my lord, last date of the before vacation, this
Okay.
order was being passed. So I computed from the last date only. So might have happened that during the vacation, some days might have been rejected. For that reason, might.
No, that Saturday you must not have calculated,
that might-
not within the vacation.
Well,
Let us see, where is that?
Proceed, my lord, with the merits of that.
It'll be there behind this. Where is the stamp? Olga sheet logo stamp reporting kai? Has to be there. But where is it?
Whether it has been done at all, I don't know.
Your physical copy there? No, must be there. Would have said SR not done, but sometimes they're not giving the proper noting also. Item 47. Jaldi de, jaldi de. Yes, yes. Date of judgment 19. That was the last date, or 20th was the last date?
So you have filed an application, no?
Well, I have filed an application because I computed from 19th of May, my lord. 19th May was the last date, my lord, before vacation.
According to them, it is a 2 days delay.
You filed on 23rd.
Yes, my
So
lord.
2 days.
My lord.
Because you have not filed on the reopening date.
No, my lord, I have not filed on the
So exactly, just 2 days. That's
I've filed a condemnation of delay, my lord.
yes.
Where is this miscellaneous application IA 3579 of 2023? Heard Mr. Panda. Shobhushachi Panda. Yeah, Shobhushachi Panda, Learned Counsel appearing to the applicant. Is an application under section 5 of the Limitation Act for condoning the delay of 2 days in filing the intercompany appeal from the judgment dated 19/5/2023, delivered in WPC numbers 16479 of 2023 by the Learned Single Judge. Stop. Issue notice as to why the aforementioned delay shall not be condoned or any other order or orders shall not be passed. Notice is made returnable on 20th of July 2023. Since Mr. Who is appearing? Mr. Naik or Mr. Kuntia? Mr.
State Consumer Commission is a
No,
party.
no, that's just
state will
just,
not be there.
oh, it is change consumer, okay. All right. The applicant shall take steps for service of notice on the opposite parties by 30th of June 2023 by registered post with edit. So it will come on 20th of July, returnable day.
May I pray for something, my lord? Lord, the proceeding is again posted tomorrow before the State Consumer Commission. So if they proceed further, my lord, it might prejudice me.
Have you filed an IA?
My lord, I have filed an IA.
And it has been rejected on the ground that there's an appeal provision.
There's an appeal provision, my lord. My lord, my short point before the honorable single judge was that there's a order which has been passed, which is beyond the jurisdiction of the honorable State Consumer Commission, because the written version should have been filed within a span of
We
45
apply for an adjournment there because these issues are because there are several conflicting decisions are available in the area. You can find also 3-4 judgment of the National Consumers Dispute Redressal Commission. They say that yes, it is you can approach the court is good, but most of the cases they say no. And so last Supreme Court decision of 2022, you just check up. This says no. They have reverted the matters back to the National Consumer Dispute Redressal.
Unless the order passes without jurisdiction, what order you are saying has been challenged, that is not without jurisdiction. They could have taken a different view. But is it without jurisdiction?
Well, the written version was being filed beyond 45 days.
All right, let us say let it come back. You file this order that notice has been issued. I think they will give you the adjournment of 20 days.
I was just, if I could just apprise my lord, I was just relying upon that judgment of Radhakrishnan Industries, my lord,
Ah.
whereby if the order is beyond jurisdiction and if there is a violation of principles of natural justice, devoid of the fact if the appeal is there, it be maintainable, my lord. That was a short point which was being there. Here, my lord, the written version has been accepted. There is no affidavit to that effect they have filed. No condemnation of delay they have filed. It was specifically recorded by the Honorable State Consumer Commission that they have to apprise this Honorable Commission that why this written version will be accepted. No such affidavit was being filed. It was merely been accepted on oral submission. My contentions was also not being taken into consideration. Now, there is a recall application also I have filed after that because I did consult with the concerned.
But all these matters, this court will not extend its jurisdiction. You know why? Will not do. It will not go into the merit of any order passed by this. Only on the solitary question of the jurisdiction, whether the jurisdiction was available with the State Consumers Commission or not, that aspect we can consider. And that's only a very narrowed there's a circle. We cannot be on. That is why we should the notice, they take advantage of that and come on the next state. We'll take it. Already 20th July.
At least if it can be reflected in the order, if I seek for an adjournment, they'll grant an adjournment without proceeding the matter.
You just then seek a short adjournment, come before us, that they will not give us. But that way, usually you do not give unless it is a very urgent issue, something very dangerous is going to happen, that we do not, before condoning the delay, we do not pass any order.
Had it been the other way around, we may have interfered without considering the written version. If they were proceeding, we would have thought of granting stay. Here it is the converse. So I don't think we should stay.
Well, let's try whatever you point you raise on 20th, we'll consider.
48.
If you find out this 22 decision or the Supreme Court has remanded the matter back to the National Commission because they have Article 142, we can also remand any matter back to the State Commission.
Ibrahim Fazal is that judgment, which was passed by Honorable Justice M.R. Shah, where they have said that the challenge was basically before court was that NCDRC's order was challenged before the Honorable Delhi High Court. The Honorable Delhi High Court entertained the writ petition. This was again challenged before the Honorable Supreme Court based on the fact that how can the NCDRC's order be challenged before the writ court? There it was being said that 227 is exercisable still.
No, because I think the 22 judgment has taken a different view. Just find out that.
48.
May I please, Your Lordship? Review a very short point. Distressed lady was dismissed. Your Lordship allowed the case distress without notice, my Lordship. And the matter was kept pending here for about more than 10 years. The Lordship directed for reinstatement without back purchase. The judgment was passed on 11/8/21, and the Lordship directed to reinstate within 2 weeks, but they reinstated on 7/12, more than 1 year after.
Wages for that intervening period or the entire period?
Entire, because of the Supreme Court decision said, my Lord, they have relied upon number of Supreme Court decisions.
How in a review petition that can be done? No, whatever is given now by a review that can be corrected. They have taken a decision, wrongly or rightly.
Findings have relied upon number of.
No, that is yeah, it was a rejection of your prayer.
No.
That at a certain period, this court has not granted the back wages. That is the case, yes. So far I have understood. And the court has rejected this prayer. How by a review you can cure that? Because it's a decision, wrong or right. And you cannot say that is a palpably wrong on the face of the record. You have to go into the merit of the case, whether you are entitled to the back wages or not.
The other part, my Lord.
No, it is a question of applying jurisdiction of review.
And the other part, Mr. Malik, you look at the impugn order. Why has it come up before us?
Well, it was directed to reinstate within the other part, my Lord, within 2 weeks, my Lord. But they reinstated me after more than 1 year and 3 months.
Yes.
No, have you filed the entire judgment? Have you filed the entire judgment?
No, enter the other.
So only the portion you're seeking review of, you have filed that.
Yes. Enter judgment.
Well, the full judgment, because I am getting it from your, this, the order that was subsequently passed by the learned judges. There are two very vital issues is that there, I am telling you. Come prepared for to answer that question. That is a well thought decision that certain date was fixed. And the opposite parties, the employer did not comply that order, right? Is the review is the remedy or?
No. Had filed after filing of the content petition, they complied it.
Done it,
After
yes.
more than 1 year and
Yes.
3 months. My lord.
No, Mr. Malik, page 16, you look. However,
was-
a
it is a-
case
it
for
is a-
notional increments will be considered. That is a separate cause of action.
I think all the matters are for a fresh writ petition because you, whatever you're claiming, it requires a fresh adjudication.
Yes.
First of all, I think the law is very, very sketchy in this matter. That when court passed that we issue the order within 2 weeks. They did not pass the order and passed the order after 6 months.
Yes.
Whether on the basis of that order, just wait. On the basis of that, whether you can claim before this court that you grant these the wages. It is a fresh cause after the order was passed. How by you have reviewed that can be cured? Because it is also your application is delayed by this some days.
There are two parts to that order, I think. You're challenging
You
the entire
think, I
thing.
think this will be in trouble, will perhaps unnecessarily just waste time. Because this will come, because the review, when the review jurisdiction can be extended in a particular order, now it's almost a settled position of law.
Yes,
So just you rethink and we are fixing the matter sometime in 21st of July.
No, are you also challenging that you are entitled to the salaries and other allowances when you have not worked?
Even if you have not worked, my lord, your findings.
No, I'm asking, are you challenging that?
Yes. Yes.
What? To some aggrieved person where he will go for the remedy. We are to be aware of our jurisdiction. You just think about these issues as that the matter be listed on 21st July 2023 at the request of Mr. S. Malik, Learned Counsel appearing for the petition.
How many days delay?
More than 500 they have not accessed.
That means afterthought you have.
No, not after.
Then-
After reinstatement, my lord, I have to, she could not, my lord, come. I have given the reason because a distressed lady, after
We
reinstatement only.
understand your grievance. There is no difficulty in that. Problem whether we can exercise the review jurisdiction or not. That is the issue we are raising. You may have a very good grievance. I think it is a newly, it should be adjudicated fresh. Review jurisdiction, we cannot adjudicate new rights created. The right you are projecting as number one. That you just rethink of that thing. Yes, call the next matter.
49.
Please, your lordships. Lordship, the brief fact of the case to control the street dog population as the main objective of this rule to implement the animal bath control program in urban areas by the local authorities to manage the street dog population in a human manner, that is by the sterilization or vaccination.
Only pray, Lordship, if it is possible, it can be fresh admission, it can be taken. 64 and 65.
Oh. 18th July, because
Lordship, Lordship, can it be fresh admissions that can be taken up, Lordship? 64 and 65. Contractual employees, Lordship, and I have employment.
all right.
Lordship, grateful. Lordship.
Item 64 and 65. The same order, huh? Read this appeal on 18/7/2023 at 2 p.m.
That full lordship.
Same order, well, because otherwise you cannot upgrade your
Lordship,
matter.
lordship. Yeah, lordship.
Yes. Other matters, will provide dates.
Others matters, lordship.
We'll
Rest of the.
provide date within a this dates will be provided.
Yes, sir. Item 52, my lord.
Hmm.
Regarding
Rest of the matter
selection
next
and appointment, my lord. Crossman, take up next week.
All right, on 18th July. 52.
Item 66, my lord.
Well, may your lordship taking fresh admission matter. My
No,
lord.
fixing it to
2 p.m. 2
Oh.
p.m.
69, my lord, 11. Item 69, my lord.
66.
Item 66, my lord. My residence certificate has been cancelled, my lord. I challenged the writ application and that has been quashed, my lord. A person who is no authority filed the challenging my residence certificate.
Is working.
66.
Saturday, no? 17th July is Monday. This 56.
66, my lord.
66. 17th July, no time to hear today, list on 17th July at 2 p.m. So
My
it will
lord,
be-
my lord,
May I
item
please-
55, my
Lordship 67, Lordship.
What
This is the
about-
matter of the custody of the child to the mother.
Item 53.
I think is a bench for someone else. Yes.
Item 72.
Huh.
Your lordship had fixed it to 2 p.m. before vacation. I pray it may be fixed on some date.
Unfortunate.
17th is okay.
My lord.
Just, at 2. 17th. All right.
Obliged.